Let's fill out a new Jersey Prenuptial Agreement together and check off every legal requirement as we go. This is New Jersey's Prenuptial Agreement, the contract a couple signs before marrying to set their own financial rules. On the right is everything New Jersey asks of it. The agreement has to be in writing, and that is the document in front of you. These rules live in one act, and the statute gives that act its short name. This is a contract between two people planning to marry, made ahead of the marriage and effective when it happens. Property here means anything either person has an interest in, now or later, real or personal. Start with the effective date, the day the couple plans to sign before their wedding. Type the month, day, and year here. Signing does not switch it on, it takes effect when the marriage happens. Next, enter each prospective spouse's name and mailing address, exactly as they will appear on the signed pages. The agreement calls them Prospective Spouse 1 and Prospective Spouse 2, names carried through the signature block and the schedules ahead. Neither person owes the other any payment or promise for this to hold. The marriage itself is the exchange. Each person has to sign it of their own free will. An agreement someone did not sign voluntarily does not hold against them. Each person has to have their own lawyer at signing, unless they give that up in a separate writing after being told to get one. Further down, a clause names which state's law governs the agreement and which state's courts would hear a dispute. This is a New Jersey agreement, so both blanks say New Jersey. The couple can pick which law governs the agreement. The attached schedule lists each person's finances. Spouse 1's copy shows a bank account, a car, and some jewelry as examples. State law sets how each person discloses what they own and owe, and what happens to the agreement if they do not. It can set each person's rights in any property, no matter when they got it. It can cover the right to buy, sell, use, and manage property. It can set how property is divided on separation, divorce, or death. If it is challenged, state law looks at whether each person got full and fair disclosure of the other's earnings, property, and financial obligations. That disclosure can be waived only if the person does it voluntarily and expressly, in writing. Spouse 2's copy follows the identical layout, with a different sample balance, vehicle, and valuable item. It can change or drop spousal support. It can require a will or a trust to carry out what the couple agreed. It can say who owns a life insurance policy and who gets the death benefit. Anything else can go in too, as long as it does not break public policy or a criminal law. The agreement closes with a signature line and a dated line for each spouse. Both people have to sign it, so neither page stands alone. The person challenging it carries the burden of proving it unenforceable. Whether the agreement is unconscionable is for the judge as a question of law, not for a jury. Nothing in here shortchanges a child's right to support. After the wedding, changing or canceling it takes another written agreement, signed by both. A change or a cancellation does not need anything of value exchanged for it. It just has to be written down and signed by both. It is not treated as unconscionable unless the circumstances the statute lists apply. Fill out your own prenuptial agreement free at FormsPal, no sign-up required.